Viewers, today is a day for us to take a larger view on a burning topic that holds great consequence for relations between two communities. This is not Rahul Shiv Shankar speaking, but this is actually the High Court, the Allahabad High Court's view. India is a secular democracy where ostensibly all religions are equal in the eyes of the state. But what if I told you that the law discriminates selectively against certain communities more than others? There are plenty of laws that have been passed expediently that cause our secularism to turn into a discriminatory article of faith, so to speak. Viewers, I can read out a huge number of these laws. But tonight, we will focus on one that is in the news at the moment. It's in the zeitgeist. And I am talking about the Places of Worship Act of 1991. Now, this particular act was passed by the Congress government of P.V. Narasimha Rao in the midst of the main opposition party, the BJP, then staging a walkout. In fact, there were dramatic scenes where Uma Bharti, during the debate on this particular law, came out with some very pertinent points to say why the BJP opposed the passage of the bill at that time. Viewers, Mani Shankar Iyer stood up and made some arguments that have been recorded for posterity. And if you were to go back on the records of that debate in Parliament, you will be quite aghast at the kind of sentiments that were expressed by those in favor of this particular law. Nonetheless, viewers, the bill was passed and the Places of Worship 1991 was enacted. The Act of 1991 prescribes that the status of a religious place cannot be altered, changed to anything other than what it was on August 15, 1947, i.e. on Independence Day, 1947. Now, some people, viewers, are wondering why in a country where places of worship were altered millennia ago, an arbitrary cutoff like this was taken to institute the status and undergird it through a law. Viewers, the implications of the law are that Hindus, for instance, cannot reclaim their places of worship that were taken over to be built over illegally before partition. For instance, though the Kashi Vishwanath temple is revered as one of the holiest Hindu shrines in India, no Shiva devotee can pray there, even though a mosque now straddles and strangles, why not, it in plain sight. Viewers, we all know that the Kashi Vishwanath temple of Lahore was demolished by a farman passed by Aurangzeb, the Mughal emperor, who was also, of course, a militant fundamentalist. Now, you may chafe at the injustice, but that is the law, and the law is the law unless it is amended or repealed. But given that the central government has not moved to nix the law, its legality is being challenged now in court, in the Supreme Court, in fact. And viewers, Tariq pe Tariq, the Supreme Court has been asking the government to take a stand. Is it in favor of this law? Does it believe that this law should remain on our books? If so, why? If not, why? But the government keeps asking for more and more time. Now, somewhere in the new year, viewers, this particular hearing will take place again. But viewers, help is at hand. The court is being pushed to take a position willy-nilly. It might wait for the government to respond, but sooner than later, viewers, this process will move on thanks to BJP leader Ashwini Upadhyay, who had filed a public interest litigation in the Supreme Court citing several reasons why the law is illegal. Now, if you look at his particular petition before the Supreme Court, you will see why he objects to it. The man to the right of your screens, viewers, is a person very familiar to us. It is a father-son duo, the Jain father and son duo, who are out there testing the legality for themselves before a court of law because they have, viewers, decided to fight for Hindu rights and get Hindus possession of both Kashi and Mathura. But viewers, what is the real problem with this law? Why should it be scrapped? Here's a quick rundown of what Ashwini Upadhyay has contended before the Supreme Court. He says, number one, the Act bars judicial review, which is the basic structure of the Constitution and cannot be taken away. The Act violates the principle of secularism as it shows preference to one religious community. Because viewers, even though it applies to all, we know that it is predominantly Hindu places of worship that were built over by wave upon wave of settler colonization. First Islamic and then the British. And on the first point, viewers, it is quite clear. You are all allowed to go to court to voice your grievance. And if that is barred, then that is an assault, viewers, on your fundamental rights. On the third point, Mr. Upadhyay says that the choice of the cutoff date, 15th August 1947, in the Act adversely impacts Hindus, Sikhs, Jains and Buddhists because it was most of their shrines, their temples, their places of worship that were built upon before this particular date. And therefore, Mr. Upadhyay says the Act negates Hindu law that deities are eternal and they do not lose land because the idols are destroyed. The deities are vested in that particular soil. The Act allows also, according to Mr. Upadhyay, Muslims to squat on temple land even though the destruction of temples does not create a waqf and is not a valid mosque in Islamic law. Now we know, viewers, that a waqf can only be created on a land which is virginal in nature, where nothing else stood specifically the place of worship of another faith. This is what Ashwini Upadhyay has contended. But let's go to our debate, viewers, and ask some of the legal experts who are stakeholders and those who have been writing about this issue. In the land of origin, can a law punish Hindus? Fundamental question being asked today, viewers. And as you know, this debate is brought to you by Motorola.
Hello, Moto.
Let's go straight across to our guest. In the land of their origin, a law punishes Hindus. It is legal or is it not legal? Let me fundamentally set this up, viewers, by getting two people first into the debate. Dr. Anand Raghunathan is here with us, and so is, of course, the spokesperson of the AIMIM, who's also a lawyer, very well-known lawyer, Waris Pathan. Let me first begin with you, Dr. Raghunathan, because you've written about this even in your book. Now, why do you believe that the case to have this law scrapped is robust, is strong, and should be upheld?
Good evening, Rahul, and good evening to my fellow panelists. To put it in one sentence, an act like this can only exist in a dictatorial banana republic. So we have to decide, are we living in a dictatorial banana republic? And if we are not, then there is absolutely no reason and justification for this act to exist. I say this for three reasons. Number one, it is not about the verdict that may ultimately come in the way of the Hindus or any other party, Hindu or Muslim party. This act denies the fundamental right of a citizen to even approach the courts for justice. This is so bizarre, it's so unbelievable that I repeat, it can only happen in a banana republic. And the fact that the Honorable Supreme Court has ratified this act in its 2019 Ayodhya judgment, in my view, I might be in the danger of being in contempt of court yet again. But in my view, it speaks volumes about the way we treat the dispensation of justice in our country. How can, leave alone Hindus, Muslims, Jains, Buddhists, anyone, irrespective of the religious denomination, be denied the fundamental right to seek justice? Yes, he or she may not get justice at the end of the day, or it might be delayed, as is the case in more often than not. Yes, the justice might not be liked. The verdict might not be liked by the party, but at least the party has a right to approach the judge. Now that is being denied by this draconian, barbaric act. Number two, and I have repeated this before, I've even said this in my book, Rahul, this is not a Hindu-Muslim issue at all. I am a Darwinian atheist, and I've said this. If Waris Pathan Saab, my Muslim brother, who's very dear to me, if he were to, for example, fight for a masjid that was demolished by a Hindu king and a temple built over it, and he was to approach a court to reclaim that masjid so that he could worship there, I would side with him and go to the court. I do not see this as a Hindu issue at all. This is a civilizational issue for every Indian, including Waris Pathan Saab, whose ancestors were Hindus like me. So I am civilizationally a Hindu as much as Waris Pathan Saab is. Unfortunately, because of our religious dispensations, we are, as Naipaul said famously in Beyond Belief and Among the Believers, or a huge community is supposed to look westwards and not towards the civilizational heritage of India. Point number three, this has been the fact, and I just narrate this fact. You can see the part demolished temple, unlike in the case of Babri Masjid, where you needed an ASI to actually do rigorous scientific analysis and find out that yes, and as agreed by the Supreme Court, that there was a massive temple of Hindu origin beneath the Babri Mosque. This was agreed to by the Supreme Court. Also, after the digging started to make the Ram Mandir, they found out so many artifacts, broken idols of the previous temple that was there, existed before the Babri Masjid was built on top of it. In this case, you can see the temple. Not only that, how ironical it is, Rahul, I'll just take 30 seconds, that the very people who accuse the Hindus of violating or going to violate the Place of Worship Act have already violated the Place of Worship Act against Hindus. And I'll explain that why. Because before 1993, Hindus were constantly doing their worship of Ma Gauri there. After 1993, the Mulayam Singh government restricted them to once a year after 1993. There is the Vyas Parivar Tehkana, where Vyas Parivar has been worshipping for centuries. They were prohibited in 1993 under gross violation of Place of Worship Act that says you cannot change the religious character of a place after August 15, 1947. The sacred people tree inside the compound where the Gyanvapi mosque now is was chopped off. The Ganesh idols were removed. The Hanuman idols were removed. 3 small shivlings were removed. Is that not changing the religious character of the place? So by all accounts, by 3 reasons I've given you, just 3, the fact remains that A, this barbaric act must go, must be abrogated, must be repealed, and the Muslims must realize that this is the most sacred place for the Hindus. If I ask a simple question, if the most sacred place of Muslims was denigrated thus, demolished thus, and a Hindu temple built over it, would not the Muslims, would not my dear friend and brother Waris Pathan Saab at least have the right or seek the right to approach the judge? That's a simple question.
Waris Bhai, I think Dr. Ranganathan has at least set up why this particular act needs to go. He's given you 3 or 4 points, and he's also very categorically said this is not about Hindus and Muslims. This is a point of principle. It's a point of order. If we see ourselves as a secular republic, we can't have aberrations such as this that discriminates against one group of citizens against the other. So, Waris Bhai, what is the reason why you think that this particular law should remain on the books despite all these objections and these challenges and these questions that are being raised?
Well, my good friend Anand Raghunathan just now made his points. He spoke about 3-4 points. He said the Places of Worship Act is a draconian act and it should be abolished, and it is not about the Hindus and Muslims, but it is about the principles. Very well, right, principles. Why was the Places of Worship Act 1991 made at that relevant time? To ensure and to see that whichever structures, monuments, places of worship are their existence prior to 15 August 1947, you cannot change the nature and character of that place. And the intention was to ensure that the communal harmony remains in the country, hatred does not spread, and because what had happened during the Babri Masjid, you, me, everybody has watched. Now let me remind my learned friend Anand Raghunathan that during the Babri case also the Supreme Court has unanimously held that there is no evidence that a temple was destroyed and a masjid was built in place of the temple. Secondly, the order was passed on the basis of faith, on all basis of evidence. Because at that relevant time also they said we have no evidence to show or to connect that some murtis prakat ho gayi thi wahan par. So it was unanimous decision, but under Article 142 of the Constitution, the Supreme Court has a right to pass an order. They gave a judgment. We lost our Babri. Now my second moot point and question is that why do you want to have a survey for Kashi or for that purpose the Shahi Idgah? Why? Because the present situation is that as per the Places of Worship Act, that both the places are mosques. In the Gyanvapi place, prayers were offered, namaz were offered. Not only that, the courts, just recently they have also directed that allow them to pray and also make provisions for wuzu khana, because they had taken order for this that the wuzu khana should not be used, and now it is barricaded. So in that scenario they have also ordered, but they want to go further. The Shahi Idgah now they have brought up, very well knowing the fact, my friend Anand and Rahul, that in the year 1968, a settlement was already entered in between the Shahi Idgah Trust as well as the Krishna Janmabhoomi Trust, and the courts have decided. It was before the courts, and the courts have held that yes, this is your part, this is your part, knowing very well knowing that. But they want to open the Pandora's box. They want the country to be taken back to the Babri era, and that is why they want to conduct a survey. What is the intention of conducting the survey? And Rahul, I respectfully disagree with the order passed by the court for the survey of Kashi or for this, because it is a total violation of the Places of Worship 1991, which clearly states that you cannot do that. But now, after the survey, what will happen? Again, a hatred will be created. Again, they will come out with some proof, evidence that no, there was a temple which was destroyed. No, sir, everything was taken into consideration when the Act 1991 was made. These things to ensure that such things don't erupt in our country, hatred does not spread, common rights does not take place, and that is what dictated happened. And I am sure during the Babri Masjid verdict, had the Babri Masjid been not demolished, had it not been martyred, I am sure the Supreme Court judgment would have been very, very different. And my friend Anand Raghunathan knows this very well. Because the Congress era, you said, open the lock, tala aapne khol diya, then you said the murti prakat ho gayi, then the Supreme Court, you filed an affidavit. And after filing the affidavit, you on the 6th of December 1994 demolished it. This was nothing but betraying. This was nothing but you just did not even follow the Supreme Court. You did not even take care of the affidavit. So we don't want to lose any of our mosques because we have already lost one. And as per my religion, my belief, once a masjid, always a masjid. एक बार मस्जिद कायम हो गई ता कयामत तक मस्जिद ही रहेगी. This is what. So if my learned friend Anand Raghunathan feels that principle की बात है, तो आनंद भाई, principle says that in present situation that the mosque is there, let it remain a mosque. Okay, this is as per the principle.
But you know the principle. Yes, yes, Dr. Ranganathan.
No, for the sake of my elder brother Waris Pathan Sahab, I must come in because it is a fact that every extra minute he spends on this debate, he loses clients because his clients are watching this, and next time they will say to the court, they'll go to the judge and say, my lord, मैंने देख लिया अपने lawyer को लड़ते हुए, मैं अपने आप अपने case को defend कर लूंगा. Did you see the speciousness with which my elder brother Pathan Sahab talked that the agreement has already been reached in Mathura? My God, does he not even know? And you know, the slip of tongue, it was not a Freudian slip. It was decidedly un-Freudian when he talked about the
1968
Krishna Bhumi. Pathan Sahab, I didn't interrupt you. When he talked about the Krishna Janmabhoomi Trust having reached an agreement, sorry, the Krishna Janmabhoomi Sansthan reached an agreement, but the sale deed is with the trust.
Yes.
So you are totally wrong. The people who do not have the property papers,
No,
they reach an
no.
agreement
You are,
with the Eidgah Trust, which is
you are
totally illegal.
lying,
So
my
please
brother.
get
You
the
are
fact
lying.
right
One second.
for
The
the sake
agreement
of
at
your
that
clients.
relevant time, those who were in
Okay,
possession
gentlemen, one
of
second.
the premises, they have entered into an agreement. Nobody can just
One
go there,
second,
enter into a settlement agreement before the court, and after 50 years you
Pathan
suddenly
Sahab,
wake up
let me
and
bring
you say
in
that no,
Ishkaran Bhandari
they were
and-
not responsible. We are the
Okay,
actual
Rahman
person.
Saab and
After
Bhandari
50
Saab are
years,
both
you cannot
waiting.
just wake up
Okay,
and
one
just go
second,
and
one
claim
second.
that,
You
sir,
see, viewers.
what, since 1968
Okay, one
till
second,
2020, you are just
one
sleeping.
second. Why are we going into the weeds of the title of a particular place of worship? I'm not on that point. I'm talking about the Places of Worship Act, which is creating a distortion, a legal distortion. So I don't really in this particular debate want to get into who signed what. And therefore, Mr. Pathan, I do agree to some extent with Dr. Ranganathan. You haven't addressed the legal points. और सब आपने बता दिया, but you haven't told me why this act should be legal. You talked about the Babri Masjid. This act was passed before the Babri Masjid was demolished. A full 12 months. Anyhow,
after debate.
Anyhow, sir, the
Rahul,
debate.
this act came into force after properly
No,
debating
sir,
in
no.
the
The
parliament,
debate, no,
and
sir.
then
The
act
debate,
was passed, law
the
was
debate.
passed.
In fact,
It
if
was
you
not
read
just
the
the
debate,
spur of
आपको
the moment that passed
one
this
second,
act.
one second. Let me just bring in
change करने।
one second. Let me bring in Ishkaran Bhandari.
Give me 1 minute.
Mr. Bhandari. Yes, Mr. Rahman, I'll come to both of you now. This is very important. Both of you need to come in. Ishkaran Bhandari, first of all, I want to ask you, of course, you can rebut any of those points on fact, but there is one small fact that I want to put before you, and I want to ask you whether the Supreme Court, while it was passing the Ayodhya verdict, whether it was within its ambit to even comment on the Places of Worship Act. Who referred the Places of Worship Act to them to even pass judgment on it? There is a very settled point in law where a court can only pronounce judgment on an issue before it.
Yes. Rahul, firstly, it's a pleasure that such an important topic is being discussed seriously where nobody interrupted anybody. I hope that trend will continue because it's a very vital debate for the nation. So firstly, your brief question, I'll answer that. Then I will answer Mr. Varis Pathan and then make my point. So briefly, a law is only upheld when it is directly under challenge before the Supreme Court. Legislation cannot be approved or disapproved without arguments, without pleadings, without entire complete framing of issues, and that's a particular method in which a judgment is pronounced. So an arbiter in Ram Mandir judgment neither upholds nor declares it unconstitutional. It will have no bearing when it's being challenged. That's the simple principle of law, applicable on all laws. Unless directly challenged, it's neither upheld nor is it struck down. Now coming to Mr. Varis Pathan, because there are so many inaccuracies that it's difficult to keep a note of them, but just one inaccuracy I will point and then I'll come to the main debate. The point is that the ASI report in Ram Mandir, the Supreme Court clearly quotes, Babri Masjid was not constructed on vacant land. There was a structure underlining the disputed structure. The underlining structure was not Islamic structure. And then they go on to say there is a clear evidence that Hindus believe that Lord Ram was born at the disputed site. Now, if you are saying that Hindus believe that Lord Ram was born at a particular site and they in 10,000 years never made a mandir there, that's a very different argument. But the ASI report is very clear on that aspect. So let's be clear on the facts. Now let us come on the debate on Places of Worship Act. It's a threefold whammy. There is a conspiracy of silence, backed by laws of appeasement, enforced by an implicit threat of violence, and I will come to all of that. The conspiracy of silence firstly is that no mandir was ever broken in India. That got destroyed over the last 30-40 years because of various movements and because of social media. Because before 80s, you would always say no mandir was ever destroyed. In fact, Aurangzeb was giving grants to build mandir. That was the debate and enough literature on that debate. So that was a conspiracy of silence. Then secondly, laws of appeasement, starting from Waqf Act to Places of Worship Act. We are not discussing Waqf Act, so I will not go into it. But Places of Worship Act in brief says a person, a victim will not have a right to seek justice. The entire constitution is meaningless if any section of the society cannot enforce its rights. That is why we have fundamental rights, but the crown jewel of fundamental rights is your ability to go to court to enforce rights. There are judgments going on since the inception of constitution where the courts have always frowned on taking away judicial review, and later it became strong enough to say judicial review is the part of basic structure. Any law violating or taking away judicial review is violative of basic structure. Places of Worship Act on the face of it takes away judicial review. So laws of appeasement. And the last point, which is the implied threat of violence. We are even today in an ASI report filed in the Gyanvapi case. There is an argument made by the Muslim side that if this report is publicized, it will lead to law and order situation. When the Barbary case was happening, there was consistent threats of law and order situation. It is only when a strong government comes and says there will be no law and order situation, enforces that there is no law and order situation, that is why we are getting this through. So in short, conspiracy of silence backed by laws of appeasement, enforced by a threat of violence. The time has come to call the bluff. Every mandir, whether it's 1 or 1,000, has to be reclaimed, because once a mandir, always a mandir.
Viewers, the conspiracy of silence bit, you can read actually in my book. I have gone into it under the chapter They took the Hindu out of the Indian. Why they did it, how they did it, this Marxist machination is exposed there. Please do read that. But let me bring in Mr. Rehman. Mr. Rehman, let's talk about the law itself. Forget about, for a few moments, the issues that arise out of it, the complications that stand before us, the monumental ones, pun intended, that stand before us. Forget those. Just get back to the law. Now, this act bars judicial review, which is a negation of the basic structure of the Constitution. How is it even valid?
Rahul, there is a concept of limitation and adverse possession in law, and it is very much needed for natural justice. If suppose after some 100 years or 200 years, Ishkaran Bhandari and Ranganathan, somebody asked them to their DNA test and asked they came from Syria or are from Indian, so it will be unjustifiable. They are living here since centuries. They may not be from Syria. But if we raise the issue, which is very in the past, and says that we should have the possession, we should give them that land, so it's against the natural justice, because some other people are living on that land. It's a natural justice to deny some rights after a limitation period. In the title suit, there is a limitation period of 12 years only. And even the Places of Worship Act is certainly past the litmus test of Limitation Act, because nobody can raise such issues in the far in future. If you have an issue, you should raise within the time limit. You cannot distort the fabric of the society, and you cannot distort the fabric of the person and the family who are living on their places. It's not just about the mosque and temple, it's about any land. You cannot raise such issue. This is a very fundamental concept, and it's a very natural concept. They cannot ruin this concept.
Okay, that's your argument. Okay, yes, Ishkaran Bhandari on the point of law. Yes.
Can I?
Yes.
Yeah. I mean, first
Rahul, when you quote laws superficially without going into the depth of it, you make the mistake Mr. Rehman has made. Adverse possession only applies where you are an open. 1 second, let me just make my argument. I didn't interrupt you. You can counter it later. Adverse possession, if it is to apply, will only apply. It will only apply. 1 second, Rahul, if I can make my point.
Rehman Saab, I'll let you respond.
Just criticize.
You will respond.
Rehman Saab, I'll let you respond. Just give him a minute. Give him a minute. You can respond, Rehman Saab. कहीं हम भाग नहीं रहे. Yes, बताइए.
Firstly, adverse possession only applies if nobody has been contesting the suit, or nobody has occupied a land forcibly and forcibly stopped you from contesting the suit. Adverse possession does not apply if you capture a property and somebody is incapable of contesting it or wants to contest it. Ram Mandir. Rahul, can I make my point, please? This is ridiculous.
We can't. We've had a very informed debate.
We were having a very serious debate.
Rehman Saab, we've had a very informed debate. Let's not speak over each other. I beg you, sir. I beg you. I'll give you just wait. Have patience. 1 minute, Mr. Bhandari. Sum up your argument in 1 minute,
just a
please.
second.
Yeah.
In 1858, Nihang Sikhs got the first FIR registered on them. So the cases were always contested. Now, if by law you stop somebody from contesting a case, you cannot claim title by adverse possession. And also the Places of Worship Act clearly says all cases will abate since this act has come into. So that doesn't apply. One last small point I would like to make here is, if I will just finish it, that very clearly that is why none of them would answer. If Muslim citizens of this country were by any law deprived from approaching court, would they want that law to be upheld? Would they not be screaming from here?
Rehman Saab, quick response to that, and I want to bring in Dr. Ranganathan. Yeah.
I want to add something.
Which law he is talking about, I do not know really, but the Limitation Act is, if the person who knows the law, he will say that Mr. Ishkaran Bhandari is speaking a lie. And the person who do not know the law, he may go with his arguments. But the law is very settled in the law in India, and has been discussed about in Parliament, and has been settled, and is being practiced even in thousands and millions of civil cases.
The matter is before the Supreme Court. Let me remind you, and the government has been asked to file a response to this question. Dr. Ranganathan, final words. Yes.
I want to ask the good advocate, my dear friend. Does the statute of limitations apply to the Waqf Act? Yes or no?
Waqf Act is itself a Waqf Act. It supersedes all other acts. Yes.
Right.
You see?
Just like the Worship Act,
so when it suits them, they don't want the statute of limitations.
Okay.
Just like
Varis Pathan.
so many acts which supersede
Not an
their
inch will be
subordinates.
yielded.
Yes.
Because
Just 10 seconds, Rahul. Allow me.
Yes,
My
Varis
good
Pathan wants to come in.
My good
This time
friend
on a point
Anand
of law. Yes, sir.
Yes,
You
please.
need a different law if you
10
want
seconds.
to.
My good friend Anand Ranganathan
if you
has
want to
today totally
supersede
lost the
everything,
debate.
if you want to
He
supersede,
very well knows places of
Worship
worship
Act, if you want
Act is
to
into
supersede
existence.
limitation
He
Act,
does
you
not
need
have
a
any
different
evidence
law.
to prove
Rahul,
his
you
point.
need a law.
So now he has
People
come
are
on the
fighting.
basis
You
of
need a
faith.
law.
My friend, the country will not run on the
Which
basis of
suits-
faith,
which
but on the
suits me.
basis of the constitution and the law which
Okay.
are laid down.
Okay.
Secondly,
Viewers,
you said that no, the Krishna Janmabhoomi Sthan, they have no right to
just
enter
one
into
point.
settlement.
Just
Sir, in
one 10-second
1968,
point.
they were actually
Just
in
one
power.
point.
They were holding the
No.
possession.
That is a point that is under contention.
They
That's a
both entered
point
into the
under
settlement
contention. Look,
agreement.
viewers.
What were you doing till now?
Okay, one second. We are again going back to the specifics of a case. I am talking about the larger law. Okay, 1 second. We are again going back into, you see, viewers, obfuscation.
Why only now? Because
Rahul,
of the
10
agreement.
seconds,
No,
please, on the
the
larger
agreement.
point.
Okay.
Just 10 seconds.
Okay, look, I have run out of
Now
time.
to come before
Just
the
10
court
seconds,
and ask
Rahul.
for a survey.
Rahul, if I can get 10 seconds, please, because it's an important point. See, the attempt was...
Okay, gentlemen, please. Gentlemen, look, I can't have everyone speak
Rahul,
over
10
each other.
seconds.
Yeah, okay, 10 seconds, Ishkan Bhandari. I'm wrapping up after that.
Rahul, the attempt was to create a Places of Worship Act to debar Hindus from claiming their holy sites, but unfortunately, because of the incompetence, they have drafted it so shoddily that Allahabad High Court says it doesn't even apply on Gyanvapi case.
Well, okay, I'll leave it. This is what happens, viewers, when you don't actually have a proper debate on a law in Parliament, when one side is stymied or one side is forced to then leave the house. That's what exactly happens, and that's why, viewers, we come back. It's like a chestnut. We come right back to the central point. The fact is, viewers, this matter is before the Supreme Court. And I can tell you one thing, and I think everyone will agree, the government can settle this very, very quickly. It has the majority, it can repeal this.